My name is Ian Giles. I'm the payroll strategist at Papaya Global, and I'll be the moderator for today's webinar. I have a feeling this is going to be a good one. Like I've said, we've got a lot going on this one today. We've invited People 2.0 to help demonstrate the importance of local compliance, and I am looking forward to hearing what they've got to say today. Not so quite to the left of me, I have Steve, the President and Global Chief Operating Officer. Steve, can you introduce People 2.0 and tell us about the rest of your team?
Yep, absolutely. Thank you, Ian, and hello, everybody. People 2.0 is a global employer of record and agent of record business, and we partner with other human capital services providers like Papaya to provide employment solutions in more than 50 countries worldwide. We do this through our own in-house owned legal entity in each of these countries, and we serve those entities through a team of local employment experts. I'm pleased to have three of our most experienced experts on the call with us today, and I'll make really quick introductions. We've got Kathy McCarthy, who is our Global Chief Legal Officer. We've got Elizabeth Beal, who is our Chief Legal Officer for EMEA. And we've got Ray Gonder, who is our Senior Vice President of Client Services. And I would say individually and collectively, these three people have decades of experience in employment law and international employment practices. So thank you. It's a pleasure to be with everybody here today.
Sounds like we've got the right people with us today. And in addition to that as well, we also have one of our own stars, Gilit Sher, Head of Global Services at Papaya Global. Gilit, tell us about yourself.
Thank you, Ian. Hello, my name is Gilit. I've been with Papaya Global for around 4.5 years. As head of partnerships, I've established Papaya's network of in-country partners in over 160 locations. On a personal aspect and related to our subject today, I've had the opportunity to relocate and work in 3 different countries. It is the company's responsibility to ensure my protection while living in a foreign country. Compliance with local laws and regulations is vital for me or anyone else as an expat or as a local. So today, we have invited our trusted partners, People 2.0, to demonstrate the importance of local expertise when companies go global. Thank you and enjoy.
Okay, thank you, Gilit. As I said, let's move on to the packed agenda. Today's webinar is an opportunity to ask the panel the questions you've been thinking about. We'll discuss the factors a company needs to consider when opening a new entity and expanding into new countries, as well as keeping things going. We'll cover aspects such as local regulations, considerations when hiring, compliance, key challenges, payments, and what not to do. It's one of the most important things, remembering what not to do. Operating on a global level is not for the faint-hearted. The bigger a company grows, the more they need to understand and manage. Knowing what to do in each new situation as it arises is important on many levels. Understanding local regulations and local laws, as well as business practices, helps mitigate associated and international expansion. Papaya, through our local experts, can navigate potential risks, such as intellectual property protection, data privacy, security issues, ensuring the company's operations remain compliant and secure. Tax, social security, returns and remittances vary by country. Taxes, for example, are generally applied on a progressive scale of up to 55%. Fines for not paying them vary and can be as high as 240% of the amount due. In some countries, non-compliance and fraud can actually come with prison sentences. Timings for filing and payments to authorities differ massively. They can be made in person, over the phone, or electronically, depending on the country. Elizabeth, if I can move over to you first. What's the most unusual set of regulations you've ever had to navigate?
Thanks, Ian. So it's perhaps not unusual, but I think what's really important to remember about working in Europe is that, notwithstanding the very prescriptive nature of those regulations in those jurisdictions, which are generally codified, that legislation, and particularly EU-derived legislation, is also interpretive, which means that its application and its scope and the way that it applies to employment law in practice can be tested through the judicial system by way of case law. Examples of that would be the Acquired Rights Directive, otherwise known as the 2P regulations in the UK, the working time regulations, which has had various strands of that legislation tested, particularly around holiday pay. And of course, as Kathy's going to come on to talk about later, employment status, which there's been multiple precedents set over the years. So I think it's really that constant evolution of the employment law landscape that you really need to navigate when working in Europe.
Okay, thank you, Elizabeth. Ray, what about you from your personal experience?
Well, moving across the pond, as mentioned, each country has different regulations, but the United States is essentially 50 countries in one, since each state has its own regulations. California's are some of the most strict. An example is payslips. On a payslip in California, the right information has to be on the payslip in the right format and in the right position. If you're in breach of regulations for payslips, the fines are issued per payslip. So that's each employee, each payslip will incur a fine.
Thanks, Ray. Thank you, Elizabeth. A lot to already think about, and we're only 2 questions in and 10 minutes or so. Hiring in one country is difficult enough, but when hiring in on a global level, it's a completely different story. You need to make sure that you're up to date with current as well as pending local labor laws. Steve, how do you make sure and ensure that the People 2.0 team is on top of an ever-changing landscape and that your clients are fully supported?
And I'll organize this into 3 key things we do, Ian. First and foremost, you need to have the right team. So we hire a team of global experts in employment practices. That team of experts includes lawyers, it includes payroll professionals, it includes HR professionals. And these are people that not only know the laws in these countries and regions, but they also know the languages, they know the local practices, they know the cultures. And it's important to have that right team and truly have the team on the ground working with clients and the employees. Second, we arm our team with comprehensive knowledge about current rules and regulations and requirements. And we do that through training, and we do that through internal databases that we keep up to date and tools for them to access that data. And third, we leverage a network of in-house outside advisors, accounting firms and legal firms who help us keep our databases completely up to date. And we also call on when we need to, when we see unusual or particularly complex situations.
Okay, thanks, Steve. I can just see a quick question in the Q&A window. Yes, the session will be recorded and sent to attendees afterwards. Moving back to the webinar itself, Ray, employer of record is regulated differently around the world. Under German law, for example, it's classed as employee leasing. Can you shed any light on some of the special considerations for countries and where the EOR model isn't regulated?
Yes, Ian. Employee leasing, or labor leasing as it's also called, which is prevalent in several countries, especially in Europe, imposes strict regulations on items such as the length of assignment. It also assigns workers to collective bargaining agreements that gives them rights and benefits. But even in the countries that don't have those strict regulations, for instance, the UK, Canada, and the Nordics, there are regulations for each country, and each worker is treated the same as all the other workers in that country, and all those regulations need to be abided by.
Okay, thank you, Ray. Kathy, moving over to yourself, what do companies need to factor in when determining contract status to protect themselves and the rights of hires? What are the pros and cons of hiring contractors and freelancers versus permanent employees?
So obviously the benefit of contractors versus employees is the flexibility for both the worker and for the employer. But I can't stress enough how important it is to have a consistent, thorough, and a well-documented compliance file for your evaluation process. I mean, it is the key in this environment right now to have a thorough process. So it's not only key for the evaluation itself, but it's also key for if later on someone says misclassification, you have your file supported by the requisite documents and the right evaluation tools to show somebody that you had a thoughtful process. And so what do you have to include in that process? It's the who, the what, the where, and the when. Who are you dealing with? Are you dealing with an individual, or are you dealing with a personal service corporation? And how are they operating? What are they doing? Is it the type of work that lends itself more to being an independent contractor than an employee? So for instance, accounting, IT, engineering, the creatives, these all lend themselves more to that evaluation of being a freelancer. Also, where are they doing it? Can they work from anywhere, or do they have to be on site and managed? Again, another key factor is the management and supervision of the worker. And then finally, when? Is it a specific project? Is it a 6-month project, 6 years? All of this is manageable, but it has to be documented and it has to be thoroughly investigated. So we have a tool, we call it IC2. We had an IC1 and we've improved it this year so that we can roll it out globally. These tools take a questionnaire list for the worker. The worker fills these questions out, and so does the end client or the recipient of the services. They both put their information into the tool, and then it does an evaluation, weighting the different questions, because not every jurisdiction has the same feeling about some of these questions. Some think they're more important than others, and it comes out with a red, yellow, or green. Red, you're probably an employee. Yellow, you're on the cusp. We can probably help you with that in terms of some of the things you need to bolster to make sure that you are given that evaluation of independent contractor, or green, where you are assessed as a independent contractor. Once that evaluation is done, all the requisite documents are underneath it, so that if later on there is a misclassification claim, you have the file for each one of these workers so that you can support your evaluation at the time and show your process, which I think is extremely key.
Thanks, Kathy. I love it. It must be the payroller inside of me, but the compliance is absolutely key from my point of view, and making sure that, all the right buttons are ticked. Absolutely fantastic. Elizabeth, let's delve into the confidentiality and the intellectual property rights side of things. What needs to be considered here, and how does it differ around the world?
Thanks, Ian. Yeah, so confidentiality is most frequently a concern for employers in relation to exiting employees. So it's really fundamental to ensure that you've considered from the outset any post-termination restrictions that you want to put into the contract of employment and that they're enforceable. So that means you need to really think about what it is you're looking to protect and why. Clearly define what's included within the scope of that confidential information, and address the period of restriction post-termination that you want to apply, and be really able to justify that. In relation to intellectual property, the position really depends on the type of intellectual property you're looking to protect, and also the jurisdiction. So for example, from a copyright perspective in the Netherlands, the end client is more likely to have the intellectual property rights in a copyright that a worker's produced who's been under their supervision and control automatically. However, in somewhere like Poland, for example, that automatic right may not be there, and that assignment would need to flow through the chain contractually. So it really depends on the jurisdiction and the type of IP.
Okay, thank you, Elizabeth. Steve, while staying on the subject of contracts, misclassifying employees is big news at the moment. What are the consequences of getting this wrong? And more importantly, why are companies getting this so wrong at the moment?
Yeah, you're right, Ian. It is becoming big news. And I think part of the reason it's becoming big news is because the consequences can be very severe, and those consequences are growing. The consequences are both, I would say, non-financial in some cases, they're reputational risk and employee relations. And then the financial consequences are from claims from various sources. And there's really two sources a lot of these claims are coming out of. One is from the workers themselves, in some cases through class action claims from workers that believe they were wrongfully engaged as contractors with rather than employees. And just to give a publicly disclosed example of that's been recently announced, and that's right here in Canada where I'm based, is Deloitte just settled a $2.5 million class action case with a group of workers that they engaged as independent contractors. And then claims are also coming from the government side, governments who don't feel they're getting their fair share of tax income when companies are engaging a large number of independent contractors. And those have been very, very significant. One of the more recent bigger dollar settlements we've seen there was last September, again, publicly announced, and it was $100 million settlement that Uber made with the state of New Jersey, one state. In addition to the publicly announced settlements, there's also significant legal costs. There's other penalties. There's other costs behind that as well. So the total cost could be very significant in the tens of millions of dollars or more, and those amounts are growing. The reason why companies are getting it so wrong is really just the rules are complex and they're changing all the time. Think IR35 in the UK, which has been an ongoing development for several years now, and still a lot of uncertainty amongst companies on what it really means and how you deal with it. Most employers are simply not aware of the rules and act as if the rules are the same everywhere, which they're not. So encourage you to be very proactive as you're engaging workers from a classification perspective.
Okay, thank you, Steve. And moving back to yourself, Ray, it's not only the company that suffers in the long run. What effects can this have on the employee, especially when it comes to their own tax liabilities, social security, and benefits, for example?
Sure, Ian. Obviously, the worker's the other side of the coin. I find time and time again, the workers often misclassified unknowingly. They don't understand the conditions of employment or contract and are told by the client why it's most advantageous, mainly to the client, why you should be employed or engaged in this fashion. The worker might owe taxes and social security to the authorities. The future pension and health care privileges of the worker can be impacted. And several times it can be years before this all falls out. And by that time, it's too late. Years have gone by. They haven't contributed to pensions, etc. So it's a big impact that they never knew they were walking into.
I can agree with you more. If you say the UK, for example, HMRC can go back as much as 10 years. Kathy, companies are taking out insurance against misclassification, but typically premiums are only covering the cost of legal fees, whilst the average claim assessed against employers equates to 40 or 50% of the base salary of worker. Is there any point in taking out insurance, and what is the alternative?
Yeah, to your point, you do need to read the fine print. It is not covering the taxes, penalty, and interest in most cases. I haven't seen it, at least. So the other area that I do think, if you manage to get the coverage, what we are seeing is that if your compliance program is not up to stuff, you could be denied coverage on the basis of the fact that you were not in compliance with laws. In the UK, we are seeing insurers also write coverage, but only if you have a fulsome vetting process in place, or you have a vetting tool that you're using from an outside agency that is doing the vetting for you. So the insurance is really not the panacea that people may think it is. The most fulsome insurance that you can have is the compliance program.
Okay, thank you very much, Kathy. Moving on to the next kind of area, we've got other key challenges. You've got your EO or worker onboarded, but they're not performing as well as you might have liked them to. What are the next steps? Who should carry them out in terms of performance reviews, improvement, and or terminations? Elizabeth, can you take us through some of the actions a client should or shouldn't take themselves when it comes to performance improvement plans, termination agreements, and severance?
I think in these circumstances, it's really imperative to work with the local in-country provider. The reason being that there are so many nuances under the local laws, which quite frankly are really easy to fall foul of. In most European countries, there are generally two grounds for termination, and they must be either objectively justified, such as for economic reasons, or the other ground is personal grounds, such as performance and conduct. The general principles around defending a claim from a worker that's been terminated for poor performance would be generally based on fairness. So a court would need to see that the employee has been given a meaningful and genuine opportunity to improve their performance or their behaviour, which requires setting clearly identified goals in order to measure the progress and achieve improvement. Navigating your way through litigated claims in jurisdictions you're not familiar with can be extremely burdensome and time-consuming and costly. So we often recommend entering into a mutual termination agreement, particularly where there's been a particularly difficult relationship between the parties. This is generally, the benefit of this is because, of course, it alleviates the risk against further claims from the worker and also avoids all those associated litigation costs as well.
Okay, thank you. Kathy, how do you handle litigation? Does People 2.0 have external counsel?
We do have external counsel on a global basis, but we handle litigation, from trying to prevent it in the first place. So our HR advisory team that is out in the field, they're briefed with any change of law on what the typical issues are that could be raised out in the field so they can handle it in the first instance so it doesn't escalate. If it's something that's not routine, it is escalated to our subject matter experts in region, like Elizabeth. Elizabeth also has a team of lawyers that are language speakers in every country and are familiar with the issues that we try to resolve the issue at that level too. And if it does look like it's going to go to litigation or a Department of Labor claim, we do have Littler, who is our employment advisor. They're a global law firm, and they have local law practices in every country, major country. We work with them. They know our business and they know the issues that we face. And our philosophy is that we like to settle or get out of these or resolve the cases quickly because we don't want them to fester and accrue more claim time and money.
Thanks, Kathy. Another great example of why the right partnership is exactly what businesses should be looking for. Steve, you must have seen all manner of things in your time without naming names. What shortcuts have you seen companies taking and why are they taking them?
Yeah, I would say the biggest shortcut, most common shortcut we see is engaging with workers as independent contractors, regardless of the nature of the relationship. We especially see this when companies are engaging with workers across borders. It may be in a jurisdiction where they don't have kind of outside of their own home jurisdiction, and they might engage with those workers who are going to work with only them and work with them for a long period of time. And maybe there's a large number of these workers and kind of common red flags we might see there. This is, of course, done because it's much easier, especially when you're talking about cross-border engagement of workers. Another common mistake we see is what we call trigger terminations. And as Elizabeth said, the requirements for terminating employees around the world can be very different country by country. And we see instances where companies will terminate a worker without taking the unique notice periods and unique protocols into account. And it results in claims that could have easily been avoided if just the right consultation had happened in advance.
Okay, thanks, Steve. Gilead, can you tell the audience why Papaya chooses to work with in-country partners in 180 plus countries and not open entities like some of the other players in the industry?
Absolutely. So as a payroll and payments platform company, we're actually dedicated to unify global workforce under one solution. There's simply no other way to know or understand the local employment laws and regulations without having experts on the ground. Every country has its own set of rules. Disregarding them can lead to heavy fines, just as we witnessed before, and lawsuits. So we carefully choose and evaluate our partners based on specific criteria, such as years of experience, skilled local staff, legal, payroll background, tax advisors, or language proficiency. It might sound obvious, but it's not. Our strategy is based on utilizing the knowledge and skills of our network of local partners. This is the only way to achieve peace of mind for our clients that manage a global workforce.
Thanks, Gilly. Ray, is there anything else that you'd like to add?
Yes, as a company moves to become a global employer, their goal is to treat the employees in each country the same so that they appear as a unified workforce. Papaya and the in-country partners help navigate that by making sure that that's compliant in each country, while to the best of our ability, making it unified so that the workers feel a part of a bigger company.
Thanks, Ray. In addition to these local partnerships, Papaya also has its own legal counsel, one for each of its regions. Papaya's counsels assists with facilitating the offboarding of global workers, reviewing our clients' confidentiality and IP agreements to ensure they do not compromise the EOR model. We also review employment agreements, manage litigation and any potential disputes, as well as mitigating risks to the company. We are just about on the half hour, so I am hoping that people can kind of like stick around with me for the next 2 or 3 minutes, and it won't necessarily eat into their next meetings, but we do have a couple of questions that we'd like to get through, so we'll move very, very quickly onto those. I've enjoyed listening to what everybody's had to say. I hope the audience does feel the same way, and as I said, that will leave us with a couple of questions. Gilly, if I can come to you, one of the questions we have and that comes up in a lot of conversations is, if I want to grant equity to employees worldwide, is that possible?
Yes, Ian, it is possible, especially if you have a local entity. You're the employer and you can grant the equities directly. We will help you with the how. When does it become more complex is when the employees are under the EOR model, meaning that you're not the direct employer, since the local employer does not own the equity. Therefore, Papaya, together with our local partners, assist with the analysis and of the equity processing per location, both for EOR clients and our payroll clients. I hope that replies to the question.
I think it does, yes, thanks very much. We have a couple of other questions, but I think they have actually been answered during the webinar. But a final question for you, Ray. I think this is one's in your wheelhouse. How do you offer a bonus or commission plan to go to global workers in the most compliant manner?
Most countries allow workers to receive commissions and bonuses, but there are employer costs that vary per country and impact things like holiday pay, etc. So Papaya and its partners help you navigate a bonus and commission plan that's compliant in all the countries that you're operating in. And again, as I mentioned earlier, is seamless between countries so that your workers feel like they're all on the same plan.
Okay, thanks very much. We have run out of time. We are taking up those that of the people's, but I would like to say thank you for everybody to joining us today. I'd really like to give a special thanks to our panel for their insights. I hope everybody has found this really, really useful. Now that we understand the significance of having local expertise when hiring globally, it is crucial to make sure that you make the right choice. With this in mind, it's important to consider your options carefully and prioritize working with companies who do align to your values and compliance standards. This approach will help you maintain a solid foundation for global expansion and foster long-term success. As a global payroll and payments provider, we know just how difficult compliance can be, which is why we've dedicated ourselves to ensuring that our standards are always met. As a regulated financial institution, we do know our way around the block. If you have any questions as we close out, would like some more information about anything that you've heard today, please do reach out to sales@papayaglobal.com or have a look at our website. Again, thank you, everyone.